application and appeal in the matter of İŞBILEN and Turk.
Yes, Mr. Counsel.
Please, Your Lordship. As Your Lordship, I think knows, I represent Mr. Turk with my learned friend Ms. Pugh
Yes.
and my learned friend Mr. McCourt Fritz, King's Counsel, together with Mr. Gurr, represent Mrs.
Yes.
İŞBILEN.
We have read the skeleton arguments, obviously, and the judge's two judgments. So you can take those as read, unless there are particular points you want to emphasise. One other thing to mention was I had a request from Ms. Pugh yesterday about breaks. My reply was that if you want to sacrifice some of your time, yes, but not otherwise.
Well, the plan is not to sacrifice any time, but what I would ask is that if Mr. Turk, who sits behind me, wishes to leave the room briefly, would you excuse him?
Yes, he's free to come and go as he
may want
pleases.
to do that. Thank you. Your Lordship should have then a core bundle, a supplemental bundle, and an authorities bundle.
Yes, I have got 3 files of supplementary and 3 files of authorities.
So I'm sorry.
And one which I haven't looked at, which has just been put on the bench.
Yes, there's some additional transcripts and the skeleton with the page references added to both the appellant's original skeleton.
But they're the same as the ones we've already got, apart from the page references.
Yeah, they're exactly the same. And also the skeleton in response to the application for permission to appeal.
Yes, I had that already, I think.
Thank you. That's also page
Well,
reference.
at any rate, your paragraph 19 statement, is there a fuller one?
Yes, there is.
Right.
Thank you very much. This is, as your Lordship knows, an appeal against an order made by Sir Anthony Mann on the 6th of March 2024, committing Mr. Turk to prison for 12 months for the reasons which were set out in a lengthy judgment handed down the day before on the 5th, which found the appellant to be in contempt of court on 5 grounds, or counts as we're going to refer them in order to distinguish them from the grounds of appeal, for breaching disclosure obligations ancillary to a proprietary injunction, which had been granted by Mr. Justice Miles 2 years before, and a further judgment given ex tempore on the following day, the 6th of March, at which he committed Mr. Turk to prison. The respondent, in her respondent's notice, has applied for permission to cross appeal, and that permission has not yet been granted, and of course that's an issue before this court. In paragraphs 4 to 7 of our skeleton, we set out a bit of the background, which I'm not going to repeat. We set out there the parties' contentions and made one observation, which was that to an extent this is accepted, but largely not, the appellant's defence to the contempt proceedings necessarily involved the court considering issues also relevant to the underlying proceedings, which he faced along with, I think, 9 other defendants. The contempt proceedings, the trial, had a number of unusual features, the first of which was that to support his case that he had not understood the terms of or effect of the order which he was said to be in breach of, and he'd not been properly advised by his former solicitors, and so we would say lacked the requisite intention or consummatiousness, one of the issues that I'm going to address your Lordship on. The appellant waived privilege over all correspondence and advice pertaining to the order of Mr. Justice Miles within his former solicitor's files. His former solicitors were extraordinarily unhelpful and uncooperative at providing that documentation, even claiming at one point incorrectly in an email from the solicitor dealing with the case in November that they had disclosed all their files, and only finally cooperating when a court summons was issued obliging them to produce 5 boxes of documents together with 2 very large memory sticks of documents. This resulted, unfortunately, in the elongation of the 6-day trial to 10 days across 5 weeks. When those documents were examined, it came to light that the appellant's then counsel who had been instructed the day before the return date after the order, had taken the highly unusual step of advising his lay client that he should dispense with the services of his solicitors, specifically on the ground.
This is Mr. Shepherd's.
Mr. Shepherd.
Text, I think it was.
It was an email, I think, that he'd not been given proper advice. And now, that was relevant, of course, to the question of the extent to which he had received advice. And from the outset of the hearing, the respondent had invited the court to infer from the fact that the appellant had instructed specialist solicitors and specialist counsel, together with specialist solicitors with leading and junior and then leading counsel, that it would have been inconceivable that he would not have received advice as to his obligations under the critical parts of the Miles J order, if I may call it that, paragraphs 16 to 18. When the Bavonis files, as I'll call them, were finally disclosed after the witness summons, it became clear that although there had been opportunities for such advice to be given, there was no direct evidence whatsoever, such as emails, texts, or attendance notes, or WhatsApp messages, which were used repeatedly by the solicitors when corresponding with Mr. Turk, that the appellant had been advised as to the scope and extent of his obligations under paragraphs 16 to 18, let alone any evidence of an explanation as to what some of the technical expressions, such as traceable assets, which was used in the order. I stress that's not accepted by the respondent to this appeal. By the end of the trial, we would say the high point of the respondent's case was that some financial information had been requested and provided to the appellant, and that Mr. Bechelet, the solicitor from Bavonas, had intended to go through paragraphs 16 to 18 with his client. That was the first, perhaps unusual feature. The second one was the appellant's disability. He suffers, and has since a very young age, suffered from attention deficit hyperactivity disorder, ADHD. And at the time of the trial, he was also suffering from an adjustment disorder. He relied upon an expert report from a consultant psychiatrist, and also, by the time of trial, he had a report from a court-appointed intermediary, which had recommended that special measures were required, including that his evidence should not be allowed to take more than 1 day. None of this evidence from the psychiatrist or the intermediary was challenged or contradicted. But despite that, the vast majority of his evidence, which was cross-examination, spanned 3 full days over a period of 3 weeks, with the last day ending at 6 o'clock in the late afternoon after a 4-hour marathon afternoon session in order to complete his evidence. Finally, in terms of unusual features, perhaps, the appellant provided a detailed witness statement and he gave evidence. Conversely, the respondent, Mrs. İŞBILEN, chose not to provide any evidence in the contempt proceedings, preferring, we would say, to hide behind mostly second-hand evidence from her solicitor, and wasn't therefore available to be cross-examined on the factual disputes which were in issue in the contempt trial. I'm not going to take your lordship to it, but accompanying the skeleton argument is a narrative description of how the trial proceeded. It's in the supplemental bundle, volume 26, page 851. It's been prepared from the appellant solicitor's notes and from the transcripts, but I should make clear that it's not an agreed chronology. It's really to assist the court with a short idea of what happened when, and although it's intended to be neutral, it is inevitably selective. So 2 judgments. The contempt judgment comprised 297 paragraphs, 89 pages, despite requests which were refused by the judge, that the judgment should be provided in draft a few days before hand down in the usual way, it was only circulated shortly after 6 o'clock in the evening on the 4th of March, so the day before judgment was listed to be handed down on the 5th of March at 10:30. When we all attended court on the 5th, the respondent made an application for the court to commit the appellant immediately, even though she was aware that the appellant's mitigation evidence was not ready, and the appellant had a very limited time to read the lengthy judgment. The judge refused that request from the respondent, but was only prepared to adjourn the sanction hearing until the following morning, 10 a.m. on the 6th of March, to allow at least some time for the contempt judgment to be explained to the appellant and for the appellant's lawyers to finalise mitigation evidence. On the morning of the 6th, the appellant served his mitigation evidence, which consisted of statements from himself and 2 family members, detailing in particular the caring role which he provided to his mother, with whom he lived. She's a lady who suffers from numerous serious medical conditions, which I'll come back to. The appellant was committed for 12 months to commence immediately. The judge refused to suspend the sentence and dismissed the appellant's application for a stay of execution on the basis that an application could be made to the Court of Appeal. He refused an application for bail or stay. He indicated that he considered that the appellant was a flight risk, despite the fact
I don't think he did say that, did he? He said he couldn't rule it out, if I remember rightly.
He did. He did. I'll come back to that if I may, but this was an appellant, of course, who attended on every day of the trial.
Well, that's the point that I picked up when I granted bail.
Yes. And as your lordship rightly says, your lordship granted the appellant bail, although in fact, regrettably, for administrative reasons relating to the prison service, he wasn't actually released for a week, but there it is.
The grant of bail pending appeal is not something that crosses my desk very often. In fact, it had never crossed my desk before, so it was a bit of a learning curve for me.
For me as well. Paragraph 13 of our skeleton sets out the grounds. There are 11, but essentially there are 6 which relate to liability, one of which, ground 3, is not proceeded with insofar as it's a separate ground. And then there are 5 which relate to sanction. Can I turn straight away then to number 1, paragraph 14 of our skeleton, knowledge, intention, understanding. We submit that the test for the required mental element in civil contempt is best set out by Mrs. Justice Proudman in the Farnsworth case. Now, I can take your lordship to the
Sorry to interrupt so early, but the judge found these breaches were deliberate. So unless you can overturn that finding, the very interesting legal debate doesn't really go anywhere, does it?
That's true. I need to do both of those things. But I do say that if he had applied the test set out in Farnsworth and Masery, then he wouldn't have reached the findings that he did. And that, I'm afraid, will need a little bit of unpicking by me. In paragraph 14, we set out Mrs. Justice Proudman's test. Person is guilty of contempt by breach of an order only if all of the following factors, and then at B, he intended to do the act or failed to do the act, as the case may be. He had knowledge of all of the facts which would make, and then leaving out the next words, because this is an omission case, of course, which would make the omission to do the required act a breach of the order. And then, importantly, we would say the act constituting the breach must be deliberate rather than merely inadvertent, but an intention to commit a breach is not necessary, although intention or lack of intention to flout the court's order is relevant to penalty. And as we've set out in paragraph 15. That test has been approved by the Court of Appeal in at least the two cases cited there. Quadrilla, Lord Justice Leggett, as he then was, in tab 24 of the authorities bundle, and then in the case of Curian in 2021, which is will be known well to your lordship, at tab 28. And then can I just take your lordship, unless your lordship would like me to take me to those two cases, to the case of Masri, to which the judge referred in his judgment. It's at tab 11 of the authorities bundle. So it's in the second volume of the authorities bundle. And at page 468, Mr. Justice Christopher Clark says this under the heading mens rea. In order to establish that someone is in contempt, it's necessary to show that, one, he knew of the terms of the order, two, that he acted or failed to act in a manner which involved a breach of the order, three, that he knew of the facts which made his conduct a breach, and there's then cited the case of Market Maker. Can be no doubt in the present case, but that the judgment debtors have at all times been fully aware of the orders of this court. It's not and could not sensibly be suggested that the conduct of which complaint is made was casual or accidental or unintentional. And we've referred to that last sentence that I've read out as the Masri caveat, if I may come back to that. And then the judge refers to the case of Stancombe before going on to deal with other authorities. Perhaps I could come back to that case if necessary. It's not necessary, therefore, for the applicant to prove that the alleged contemner intended to breach or knew that they were breaching the order. That's set out clearly in Masri. However, what we would submit is that in the context of this kind of alleged breach, it is necessary to show that the contemner intended an omission in disclosure. And if I can take you, if I may, to another authority, to Varma and Atkinson, which is in the Lordship's Authorities bundle at volume 3, it's the judgment of Lord Justice Rose.
Lady Justice Rose, I think.
I'm sorry, my lord.
Lady Justice Rose.
Oh, I do. Of course it is. My apologies.
Sorry, which tab?
It's
27. Yes, got it.
Tab 27, page 960. Perhaps I could go back a little bit to perhaps paragraph 52, which is on page 959. Lady Justice Rose is there reviewing the authorities which she's been referred to, and to Arledge, Eady and Smith on contempt, and to a case called Ertelli. Then at paragraph 54, her ladyship says, in my judgment, Ertelli and Squattriti cannot stand in the light of the many earlier and later cases which establish that once knowledge of the order is proved, and once it is proved that the contemnor knew that he was doing or omitting to do certain things, then it's not necessary for the contemnor to know that his actions put him in breach of the order. It's enough that as a matter of fact in law, they do so put him in breach. And then, last paragraph from this at 55, she says, findings 3 and 4 provide 2 examples of facts where the distinction is important. Mr. Varma knew of the court order directing GCFZE to provide an affidavit. He knew that he was the sole director and that no affidavit had been provided. That's enough to fix him with liability for the breach of the order. he knew also that he'd been ordered by the court to send letters of instruction to that company's Emirates Bank, and that if he had refrained from sending them, he's liable for that breach, even if, as the judge accepted, he thought he did not need to comply, whilst his application for permission to appeal and for a stay was pending. And what we would submit is that the position is more difficult in respect of allegations that an alleged contemner omitted to do something. If an alleged contemner is prohibited and then does an act, then it is relatively easy to demonstrate that he intended to do the act prohibited that he's prohibited from doing. It's more difficult with omissions because in some cases, as in this one, nothing is done at all. And for contempt to be proved in the case of omissions, we would submit, he must at least know that he has information, and the decision not to provide it has to be deliberate and intentional, not inadvertent or accidental. And I read the passage from Justice Rose's judgment in paragraph 55 because in my submission that's what she's saying in that paragraph. And the same point again is made again in sector guard. If your lordship would turn to tab 9 in the authorities bundle, so I'm afraid we're in volume 1 now. At 397. Sector Garden DN PLC, decision of Mr. Justice Briggs. Top of the page at paragraph 32, he says, by contrast, I accept the thrust of Mr. Grant's second submission that failure to perform an impossible undertaking is not a contempt. That's not, of course, this case. The mental element required of a contemner is not that he either intends to breach or knows that he's breaching the court order undertaking, but only that he intended the act or omission in question and knew the facts which made it a breach of the order. And then at 33, nonetheless, even a mental element of that modest quality assumes that the alleged contemner had some choice whether to commit the relevant act or omission. An omission to do that, which is in truth impossible, involves no choice at all. Failure to comply with an order to do something where the doing of it is impossible may therefore be a breach of the order, but not, in my judgment, a contempt of court. And the distinction that Mr. Justice Briggs is dealing with there, namely between proving a contempt and proving a breach, is, in my submission, important in this case, because when one looks at the judge's judgment in this case, we would submit that repeatedly he conflated the question of breach, the breach of the order, whether Mr. Turk acted to the best of his knowledge and ability, with the question of contempt, which is another stage again we would submit, whether that breach consisted of an intention to fail to disclose. Now, at paragraph 26, can I take your lordship?
Before you leave
Yes.
32,
Yeah.
It's an expression you see in a number of cases, and knew the facts which made it a breach of the order. What are those facts?
In this case?
Well, either generally and or in this case. In other words, what are the facts that you need to know which make it a breach of the order?
Well, he needs to know what it is that he's obliged to do, in my submission. If not, there's a danger here that a breach by omission, he could do absolutely nothing and be found to be in breach and in contempt, which, as I say, we submit is a slightly different concept. Can I take lordship to the judgment to paragraph 26. This is the paragraph 26, the judge refers to the authority, Justice Proudman's authority. Mr. Counsel sought to achieve this by reliance on Mrs. Justice Proudman's reference to contempt and not breach, a reference to intentionality, and to the fact that the order required compliance to the best of Mr. Turk's knowledge and ability. And then he says not all breaches were a contempt. If Mr. Turk did not understand what was required of him under the order, then he nonetheless acted to the best of his knowledge and ability. His breach was therefore not intelligent, and I think his lordship was effectively summarising my submission to him. Relying on Mrs. Justice Proudman's formulation, that meant that while he may have been in breach, he was not in contempt. I reject this analysis and this submission. First, I don't consider that Mrs. Justice Proudman was intending any formulation which was different from that in Masry. She was not intending to introduce a distinction between breach and contempt. Her first sentence was merely describing one type of contempt, breach of a court order. There are, of course, others. And he gives an example. She was separating out the type of contempt before her. Courts have not drawn the distinction between the two words which Mr. Counsel relies on. And then his lordship gives an example, namely the case of Keir, which, of course, is a judgment of Lord Justice Nucci, which I'll come to in a moment. And he then refers to paragraph 25. The essential requirement is that the respondent should know what he is alleged to have done or not done, which constitutes a contempt. That, to my mind, focuses on the acts of omissions which are said to constitute a breach of the order, rather than the mental element required, the mens rea. With respect to his lordship, there's nothing in that paragraph which doesn't draw a distinction, if I can call it that, put it that way, between breach and contempt. If I can take you to here, please, it's in the authorities bundle again at tab 25. So in the last tab in volume 2, this is the judgment of Lord Justice Nucci, and the page is 785.
$785.
785, I think. Yes. Justice Nucci at paragraph 26 says this, but quite apart from this, it's common ground that it's not necessary to prove contumacy in order to establish contempt. What needs to be proved is, as set out in Masry, it refers to paragraph 19 above, that is, as well as the acts or omissions which constitute the breach, knowledge on the part of the respondent of 1, the order, 2, the facts which make the conduct a breach. But as Mr. Grant himself pointed out, it's not necessary to prove that the respondent made a deliberate and willful decision to breach the court order, or even to show that he knew that his conduct was a breach. And his lordship refers to the case of Sectiguard, to which I've taken your lordship already at paragraphs 32 and 3 of that decision. So a breach can involve no choice or intent at all to commit the relevant act. A breach of the order can, as Mr. Justice Briggs says in that passage at paragraph 33, to which Lord Justice Nucci refers. But what the court needs to do is to determine whether or not there is a contempt. And the three-limbed formulation in Farnsworth, which requires there to have been an intended act or omission, has, as I've said already, been approved by the Court of Appeal on more than one occasion. And it is, in fact, although Sir Anthony Mann said otherwise, the test in Farnsworth is, in fact, no different from the test in Masry, where Mr. Justice Christopher Clark was saying that there was no need to establish that the defendant knew that he was in breach of the order. So whilst he was correct to hold, that paragraph 27 of his judgment, the judge had not intended a different formulation in Farnsworth, Mrs. Justice Proudman. He then failed to construe or apply either the Farnsworth test or the test in Masry, including what I called the Masry caveat. And it's significant if your lordship goes back to the core bundle and to paragraph 23 of his judgment. Forgive me, it's not. It's at page 158.
Yes, 23 is where he quotes Masry.
Quotes Masry, but what he doesn't do, he stops before he cites the caveat. The additional words in Masry. Can I perhaps remind you?
Yeah.
Does your lordship have the point? There's an additional sentence which I've described as the Masry caveat, which makes clear that that isn't the end of it, just as Mrs. Justice Proudman does in Farnsworth. And as a result, in our submission, the judge failed to ask himself whether the appellant intended non-disclosure of the information which was the subject of the grounds of contempt. As I said already, where a positive act constitutes the breach, it's almost always self-evident from the act whether or not there was an intention. That can be readily inferred, but by no means is the same as the case when the breach constitutes an omission or omissions. And the appellant's evidence, of course, was that he had not intentionally withheld any information. And with respect, the judge, in characterising the appellant's evidence and submissions as depending on an absence of intention to breach the order, was nothing to the point. Of course, the applicant doesn't have to prove an intention to breach the order. And we would submit that had the judge applied the Farnsworth test and the Masry test with its caveat, then whilst he could have found the appellant to be in breach, he would not have concluded that the appellant had committed a breach, a contempt rather.
I'm sorry, I don't understand that. He did find that Mr. Turk was deliberately withholding information because he didn't want to comply with the order. That's his finding of fact. Now, as I said to you a little earlier, unless you can get rid of those findings of fact,
Yes.
whether there is this slight nuance in the test doesn't really get you anywhere.
Well, what we would submit, and I'm going to come on to that in a moment, but what we would submit is that you do have to have knowledge of something. You do need to know before you can be said to have done anything intentional.
Well, I think if Mr. Turk knew fact X and did not disclose fact X, and fact X was in fact required to be disclosed, then that would be a breach. It
would be a breach, but it wouldn't be a contempt, is our submission, because he needs to know that he's required to do that.
As I see.
And that's what we would say at any rate. There's the distinction. And with respect, Sir Anthony Mann wasn't prepared to draw a distinction between breach and contempt, and specifically says so in his judgment. Can I go on then to seek to make good my submission, therefore, that on the facts of this case, he could not, applying the right test, have found that this appellant was in contempt. The burden, of course, is on the respondent to prove to the criminal standard that the test had been met. It wasn't for the appellant to disprove anything. The judge repeatedly indicated that even though there was no record of any advice being given, let alone what that advice was, advice must have been given. And in reaching his findings on the advice that was given and the level of understanding, we would submit respectfully that the judge failed to apply the legal principles on the drawing of inferences.
Fails to apply.
The principles relating to the drawing of inferences, and on how to approach circumstantial evidence in a case where, of course, the burden of proof is on the applicant and the standard of proof is the criminal one. In particular, we say that he failed to apply the criteria that an inference on essential element of the case must be compelling. That's taken from Masry. And that particular care should be taken to ensure that any conclusion of guilt is based upon cogent and reliable evidence from which really the only inference is one of guilt. Judge's finding at paragraph 284 of his judgment, that's at page 233 in the core bundle in tab 11, that the appellant had received appropriate advice and that he simply did not want to comply fully, went, of course, to both knowledge and intention, and were inferences going to an essential element of the case which the applicant had to prove. But we would submit they were not based on cogent and reliable evidence from which only those conclusions could be drawn. Indeed, quite the opposite, as became clear when Bivonus finally made disclosure of its files. With respect to his lordship, the judge's instinct, as he had been invited to do when the case was opened, was always to assume that the appellant's former solicitors had acted properly and competently, even though such an inference wasn't underpinned by cogent or reliable evidence. The result was that the judge reached conclusions based upon inferences which were, with respect, unsupported by the evidence, or ones which no reasonable judge could have reached. His lordship set out in some detail in paragraphs 243 to 293 of his judgment, 50 paragraphs, the chronology of events. There was also a chronology which the judge was given during closing submissions. It's at tab 18 of the supplemental bundle. I wasn't going to take your lordship to it. The reason it was provided to the judge was that all of this, of course, was happening rather late in the day, and the complete chronology was only became clear late into Mr. Turk's cross-examination. And so it was in order to assist him, if it did, in setting out his chronology. The judge dealt with the issue of the advice that Mr. Turk received in relation to two time periods. The first of which is from the date of the order being served upon him on the 11th of March until the return date on the 18th, a week later. And then thereafter, from the 18th onwards. And as I say, he covered the sequence of events in his judgment. Can I turn first of all to the first time period? So that is from service of order until the return date, and very late in the day, on the afternoon before the return date, Mr. Shepherd was instructed. On the evening of the 11th of March, Mr. Turk contacted Mr. Bachelet of Bivonus to ask for his assistance fairly shortly after he'd been served with the order. On the afternoon of the 17th of March, as I've said, so that's the day before the return date, counsel Mr. Shepherd was instructed to represent the appellant at the return date hearing on the following day. There was then an exchange of emails, which the judge has dealt with very fully in his judgment, between Mr. Shepherd and Mr. Bachelet, starting at 3:15 in the afternoon until 11:15 at night, in which Mr. Shepherd was clearly becoming increasingly concerned about how the appellant, through him, was going to be able to say that he complied in full with his disclosure obligations on the following day. Mr. Bachelet's initial response, and this is referred to by his lordship in paragraph 253 of his judgment.
253.
Paragraph 253, yes. It's at...
This is the Shepherd email, is it?
No, it's
No,
a little
it's
bit before
Bachelet.
that.
Yes.
It's the exchange between the solicitor and and barrister. Mr. Bechelet's response then was that he had sat with him, Mr. Turk, and read out the Miles order and gone through assets identified by the respondent and anything he needs to disclose. His lordship then set out what information was provided by the appellant, and it is clear that that information came nowhere near to complying with the obligations under paragraph 16 to 18, as the judge accepted when he observed in paragraph 254 that the emphasis at that stage was on his own asset disclosure, which of course was a separate obligation under the order. And Mr. Shepherd made that point to Mr. Bechelet in a late night email at 12 minutes past 11, referred to by the judge in his judgment at paragraph 257, to which it was late at night, he received no response. Early on the following morning, Mr. Bechelet, having read the late night email and a table which counsel had drafted, sent the appellant an email at 3 minutes to 6 in the morning asking him some further questions. To the extent that those further questions went to the appellant's disclosure obligations under paragraphs 16 to 18, nobody seems to have followed that up with the appellant in order to obtain that information. Next event, during the short adjournment of the return date hearing, this of course was a hearing being held remotely, there was a Zoom call between Mr. Shepherd, Mr. Bechelet and the appellant. There's no record of what was discussed in that Zoom call. And the appellant, when he gave evidence before Sir Anthony Mann, gave evidence that he's no recollection of any advice being given. And Mr. Shepherd doesn't refer to any advice being given on paragraphs 16 to 18 in his later email, the one that your lordship just referred to, which I'm going to come to in a moment. And had he given such advice, one might have thought that Mr. Shepherd, in what was a lengthy email, would inevitably have referred to the advice. Instead, at 20 to 6 in the evening, after the hearing had been completed, Mr. Shepherd took the highly unusual step of writing direct to his lay client to advise him that it would be in his best interest to change solicitors. Your lordship has that email in tab 38 of the supplemental bundle at page 1057. Summarising it, if I may, he explained that he'd reached that conclusion because the correspondence sent by Bivonas failed to comply with the disclosure requirements, that he had real concerns from the email exchanges that he had with Mr. Bechelet. Those are the ones that I've referred to late at night and in the following morning, and that instructions had not been taken, these were his words, regarding the requirements of paragraphs 16 and 18, and that the appellant was not aware of the full extent of the disclosure requirements. He went on to say that from a brief discussion over the short adjournment, the Zoom call, it was clear that Bivonas had not advised the appellant that the disclosure failed to comply with the order. Indeed, he then referred to a WhatsApp message. The three, as often happens, of course, were conversing with each other during the hearing by WhatsApp. And he refers to a WhatsApp message which Mr. Turk had sent shortly before the short adjournment, when the appellant had expressed surprise when he had heard that the Respondents' Counsel, Mr. McCourt Fritz, repeated submissions that he had not complied. His words were, "John," that's Mr. Bechelet's first name, "what, we haven't complied." Despite all of that, the judge was able to infer a number of things. Can I invite the Lordship to turn to paragraph 254?
254.
254 in the core bundle.
Yes.
He says, it can be seen from this. Now, this is the first period, so to speak, that we're talking about. the emphasis was apparently on disclosure of personal assets. That's a reference to the questions that were asked of Mr. Turk in the correspondence which took place immediately before the return date hearing. There are two references to the order being read out. Mr. Turk's evidence in re-examination was he didn't recall sitting down with Mr. Bechley and going through the order. I note that this is not a complete denial of his going through the order, and I find that Mr. Bechley must have done what he said and to have gone through the order and explained what was required. There's a difference between what Mr. Bechley was able to do and what Janes were able to do. That's a reference to Mr. Turk having made clear that although my instructing solicitors had taken time to explain the order, he said that exercise was never carried out by Mr. Bechley. By the time Janes became involved, there was more of a target or context of understanding, namely all the contempt complaints. And then, if I may, reading a little bit further, when he explains the contrast that Mr. Turk sought to draw, but nonetheless, he will have, Mr. Bechley will have, gone through the order and the obligations in a more general way. He cannot have ignored them. And then, before coming on to deal with these inferences, 2 paragraphs on, at paragraph 256, his lordship says, in his cross-examination, he accepted that it was possible that Bavonis offered an explanation of his disclosure obligations, but he didn't take it in. There's nothing in all of this which is inconsistent with the finding which I make that Bavonis gave an explanation in general terms, i.e. not focused on particular tracing paths, because they did not know what they were at the time of the disclosure obligations. There's no good reason why they would not have done that, and good reasons why they would. We would submit those findings, of course, they're not made on direct evidence, but by drawing an inference that the solicitor would have given advice, despite the fact that that is entirely contradicted by the email from Mr. Shepherd, which followed on afterwards, and completely unsupported by any records in the solicitor files whatsoever. No attendance note of any advice, no record of what was said in the Zoom call during the short adjournment, and no proper record, any record, of what had taken place between the 11th of March and the return date on the 17th of March.
Is it right to say that what Mr. Shepherd thought was the position was an inference he had drawn from, presumably, what he'd been told by the appellant?
Well, yes, and also, of course...
Mr. Shepherd had no direct knowledge of what was advice.
Well, that's true, although he would have, if there'd been instructions, if that exercise had been carried out in the week since the order was served, then one would have expected there to be instructions on that, and I suppose it's a reasonable inference for him to have drawn that those instructions had not been given and advice had not been received.
Well, there's Mr. Shepherd also says in the email quoted at 262, he briefly records his advice that Mr. Turk hadn't complied, consequences, and towards the end of the quotation, he says it's no answer for him to say he is a relaxed guy or that it's not serious compared to the position facing C's husband in Turkey, etc., which presumably Mr. Shepherd got from Mr. Turk, or via Mr. Bechley, perhaps.
We simply don't know where it came from, and I think, maybe I'll be corrected from, I think Mr. Turk was asked about that in cross-examination and didn't have any recollection of saying those things. May I turn my back a minute?
He didn't deny when he was being cross-examined that he had been given advice.
I'm sorry, my lady.
The appellant did not deny when he was being cross-examined that he'd been given advice about the effect of the order. See paragraph 255.
He says he doesn't recall. This is 2 years later, before he has any, wouldn't have helped him anyway, has the benefit of any of the Bavonis files which may have assisted him. It's for, after all, the applicant to prove her case. Sorry, can I take instruction? Yes, the comment "relaxed guy" comes from an email, I think, from Mr. Bechelet. And as I say, when asked about it, I think Mr. Turk had no recollection of that. It might, of course, have been an observation that Mr. Bechelet made as to Mr. Turk's demeanour. Can I then take you to paragraph 267 of his Lordship's judgment? What he says here is, this is the relaxed guy in quote, in fact, which your Lordship's already taken me to. What emerges so far from this narrative in terms of Mr. Turk's understanding of the order or lack of it is as follows. Despite the fact that one would have expected Bavonis to have explained the order to Mr. Turk and made him understand it, it appears that his understanding was lacking. That, at first blush, is helpful observation from our point of view. That is surprising because I consider it to be the case that Bavonis would not just ignore the proprietary disclosure orders, and they must have discussed this then with him. It's apparent that when Mr. Shepherd discussed the matter with Mr. Turk, he got the clear impression that Mr. Turk had not hitherto understood what he needed to do, or at least not fully, and that perhaps is a reference to the WhatsApp message. I consider that at this time he had not fully grasped his obligations. However, having seen how Mr. Turk conducts himself in the witness box, I consider him to be an intelligent man who was capable of understanding the sort of thing that he had to do, and that his apparent failure to grasp matters was likely to be a combination of the magnitude of the task, as it must have appeared, casualness, brackets, he was a relaxed guy, an element of willful blindness. This is not the same as the sort of lack of focus which he claimed to have. It was an unwillingness to face up to what he had to do. And in my estimation, those findings, inferential findings, were simply not ones with respect to which his Lordship was entitled to draw from the evidence which he had heard. Mr. Shepherd has recorded in his email that this appellant had not been advised. This was, with respect, not a case of willful blindness, or, from wherever that expression came from, too relaxed an attitude. The conversation during the short adjournment between Mr. Shepherd and his lay client, from which the barrister got that impression, was in the presence of Mr. Bechelet. Had Mr. Bechelet given advice to his client at any time up until that point, then inevitably he would have said so during that Zoom conversation during the short adjournment. And there's no reference to that from Mr. Shepherd in his email, nor would he have been writing what he did write in his email.
Do we need to feed into the mix what the judge said at 245 about the letter which accompanied the order when it was served on Mr. Turk? Which he says that it summarised the disclosure obligations in terms which I find to be a readily comprehensible and appropriately accurate account, terms of which I would expect Mr. Turk to have able to understand. Took the order, read it 3 or 4 times, read the penal notice.
He certainly said he read the order. Quite what advice Mr. Bechelet gave or instructions he received as a result.
That's the letter.
Yes, as a result of sending on that letter.
Accompanying the order, which is readily comprehensible and appropriately accurate.
Yes, but that rather presupposes that it was sent on and discussed with Mr. Turk.
No, it was served. The letter was served on Mr. Turk. That's what the judge says at 245.
Yes.
So he got the order and he got an explanatory letter, which the judge finds to be readily comprehensible and appropriately accurate.
Yes.
So that must go to whether the judge was entitled to make the finding he did about Mr. Turk's understanding.
It does. It does. But my submission are taking everything together, particularly, I'm sorry to keep going back to it, but it's a hugely important piece of evidence, particularly in the light of the Shepherd email, but everything else as well. This was not an alleged contemner who'd been advised to the extent that is now being suggested he was.
received this letter and read it and understood it, and he wasn't getting advice about it, about his obligations, why on earth didn't he ask?
Well,
That's a rhetorical question, but
yes, it is.
it's the sort of thing the judge may well have had at the back of his mind.
My lady, I accept that's a factor, but he was provided with a lot of documentation, and in my submission, unless there's proper evidence that it was explained to him, and I don't want to deal with it now, but I will. Of course, this is an appellant. This is a man who is suffering from difficulties of comprehension. I'll come on to in a little while, if I may. Well, can I deal with the second time period? So this is the period after the 18th of March. On the 19th, the day after the return date, and after Mr. Shepherd's services had been dispensed with, Mr. Quirk, Queen's Counsel, as he then was instructed to represent the appellant. He deals with that time period from, his lordship deals with that from paragraph 271. Mr. Bechley introduced himself on the following day, that's the Saturday, telling him that the papers would follow, and making clear that they needed to prepare an affidavit disclosing assets by 4 p.m. on the following Monday to head off cross-examination. There was, I think, an indication from the applicant solicitors that they applied to for an order that the appellant should be cross-examined. Mr. Quirk replied that one of the main points for the respondent was that the appellant had failed to give an account of the location of the respondent's monies, and he said once the asset disclosure is done, this is an important point to get instructions on. And then Mr. Bechley hands over the reins, so to speak, to Mr. Litovchenko, another solicitor from Livonas, who replied by attaching a draft list of questions and requests for documents, a version of which, parts of which were added later, is at tab 39 in the supplementary bundle at page 1062. And Mr. Litovchenko suggested a Zoom call with the appellant. In fact, on the following day, a Sunday, there were 2 Zoom conferences. The first with the appellant, Mr. Quirk and Mr. Litovchenko, and then secondly with the 3 of them and Mr. Gary Lewis, who was the 10th defendant, and the director of the 2nd and 4th defendants. Mr. Turk accepted in the course of his evidence that although he doesn't recall seeing a copy of the questions and requests for documents, he accepted that the answers in red in that document would have been provided by him. On the following day, a draft affidavit and exhibit was served on the respondent and containing the information provided by the appellant in those 2 Zoom calls. An affidavit which Messrs. Peters and Peters described as being woefully inadequate in their letter of the 23rd of March. And there's no evidence again of the appellant being told, no record at any rate, of the appellant being told that the information would not be sufficient to comply with paragraphs 16 to 18, that it was woefully inadequate, as was being suggested, nor that there was any attempt to follow up on those inadequacies with their client after receiving the respondent's solicitor's letter. There was then a further hearing before Deputy High Court Judge Ms. Pat Tracy on the 25th of March, at which the appellant consented to being cross-examined. And from that moment on, as the Bavonas files show, the appellant's legal team focused on other matters, such as preparation for that cross-examination hearing, an attempt to collect evidence which might require the respondent to increase the level of her undertaking in damages, rather fruitless exercise, the work that was required to draft the defence, which was nearly due, and on what, frankly, was a hopelessly misconceived application for reverse summary judgment. And we've referred at paragraph 35 to a letter from Bavonas to Peters and Peters indicating that, dated the 1st of April, that since that date, that's the 24th of March, we focused on our client's defence and asking for an extension of time to file it.
Can we just go back a little bit?
Yeah.
The return day, I think, was the 22nd of March, or the time for filing, the extended time for filing the affidavit.
Yeah.
And as you quite rightly say, the judge pointed out all sorts of Zoom calls on the 21st of March. That's the day before the affidavit is due.
Yeah.
And then he says at 2:80 that by the end of this part of the process, that is on the 21st of March, he did not accept that Mr. Turk didn't understand the sort of thing that was required. A few lines further on, he says he was capable by himself of understanding the order and what it required.
Yeah, and that's an inference we submit that should not have been drawn, if I
Is
may.
that an inference or is that a finding of fact?
Well, it's an inference. It's a finding of fact based on an inference, because if, for example, there was a record of advice being given, or an email from Mr. Turk saying, yes, I understand this, then of course there would be direct evidence, but there's complete absence here of those kind of documents. Can I come back to the inferences which I submit he should not have drawn just in a moment, but just completing the chronology. On the 6th of April, it's quite properly referred to by his lordship in his judgment. On the 6th of April, Mr. Lutschenki recorded an email to the appellant that he had given instructions, the appellant had given instructions the week before, that he didn't wish to challenge the freezing order, and that his legal team should then focus on preparing his defence and his cross-examination. Now, the judge, in my submission, drew a number of inferences from that sequence of events. They're set out in detail in our skeleton argument at paragraph 37, but can I be quite selective and just take your lordship to one or two of them? At paragraph 270.
270?
Yes, this is paragraph 37, that's our skeleton. He says, so this is page 226. He says, it seems to me to be inevitable that Bavonas would approach their tasks going forward, so this is after the first time period, with the history in mind, and would be well aware of the need to make sure that Mr. Turk understood, and so far as they could achieve it, would comply with his obligations. That consideration informs the conclusions as to what happened thereafter. In other words, although his lordship didn't put it in this way, they've been given a reminder of their obligations by Mr. Shepherd in that email, and from that moment on, they would inevitably take that and provide appropriate advice. With respect, if that were indeed the case with these solicitors, then one would surely have expected them to have recorded the advice being given. If questions were likely to arise as to what advice was given, or as to the lack of advice, then one would surely have expected, if any inference is to be drawn, that those solicitors would have recorded any advice, and there is nothing. And then at 282, his lordship says, this is page 233, the third line. Although, as Mr. Counsel observed, there was no direct evidence that Bavonas followed up on any of these matters with Mr. Turk, I consider that they must have done so, because the subsequent debate about cross-examining Mr. Turk, which was eventually agreed, must have proceeded from Mr. Turk's being made aware of the fact and nature of the complaints made against him. Again, in my submission, that's not a safe inference for the judge to have recorded even if there had been a discussion with Mr. Turk about the kind of questions that he might be asked in cross-examination. At 283, His Lordship referred to a letter written by Bevonas to Peters and Peters and inferred in the second half of that paragraph, it's not conceivable that this letter was written without proper instructions from Mr. Turk, and taking those instructions will have involved his understanding the concept of traceable proceeds. This letter in this point was not put to Mr. Turk, but I consider my inference as to Mr. Turk's participation in its preparation is nonetheless inevitable. Again, it's an inference being drawn with the greatest respect in the complete absence of any record of any such advice being given or instructions taken. And then finally, in relation to these at 284, he says at fourth line, I find that while there may be no record of a positive explanation given in terms of a note actually recording the giving of paragraph by paragraph advice, I find that appropriate advice was given to Mr. Turk about what he had to do. There's no note at all, let alone one recording the giving of paragraph by paragraph advice. That will have been at various stages, as appears above. The absence of a clear record of what any of them actually said, and the absence of a written letter of detailed advice, is no doubt explained, he says, by the fast-moving nature of the exercise. Its absence is not a powerful indication that the advice was not given. But of course, there's another inference which can be drawn from the absence of any record, which is that the advice was not given. I dealt with, in paragraph 38, we set out what was lacking in terms of documentation, and I'm not going to repeat it because I'm conscious of time, but we set out there under paragraph 39 a complete lack of documentation as to advice given or instructions taken, or even instructions to counsel as to what the client had been provided. And one might think that the natural inference from all of this was that if there was no note, that was because no advice had been given, particularly, as I've said already, when, as the judge had observed, the solicitors had been roundly criticised for their failures by Mr. Shepherd.
Can I ask a question, please, Mr. Counsel?
Yes.
Who bears the burden of proof on this aspect of the case? In other words, the defence that I wasn't given proper advice by my solicitors.
My lady, we would submit that the burden of proof remains on the respondent. It has to prove, she has to prove her case.
How can the respondent prove what advice the appellant was given by his solicitors? I mean, what I'd suggest, I'd be interested for your comment, is if the appellant is going to say, I didn't get proper advice from my solicitors, it's for him to prove. There's an evidential burden, at least, on him to show that he wasn't given the advice.
Yes.
And has he discharged it?
Well, that may well be right, my lady, but he has done everything that he could to discharge it. He said I wasn't given advice.
He hasn't called any of his solicitors, for example.
No, well, he certainly hasn't done that.
Anyway, it's just a thought.
No, it's a good thought, my lady. But the reality is that one can well imagine the response. I haven't taken your ladyship to the chronology itself, but the solicitors from Bevonas were completely uncooperative.
It just strikes me it's a little bit strange to suggest that it's for the respondents to prove what advice he did or didn't get, particularly when there are issues of legal privilege in the mix.
Well, I take that point, but the legal burden of proof, irrespective of whether there's an evidential burden for the appellant to raise it, remains with the respondent in my submission.
Okay, thank you.
And so far as inferences could be drawn, the judge either ignored or dismissed the inferences in the appellant's favour. The first of which is the appellant's decision to waive privilege. That was made at a time when he had not even seen the Bivonas files. When it became apparent that Bivonas retained significant amounts of the files, he repeatedly demanded the files and supported the respondent's application for a witness summons. It would have been extraordinarily foolhardy, to say the least, to take the risk as to what those files would reveal if the risk that those files would have revealed that advice had been given. And the natural, and we would submit surely only inference, was that he believed, rightly, that the solicitor's files would bear his recollection out.
And this is not something the judge ignored.
No, it's not, but he pretty much dismissed it with respect. Can I take your lordship to paragraph 286?
Yeah. Well, can we just start with 285?
Yeah.
Because that's where the judge is asking himself the question, boils down to whether Mr. Turk understood, whether from advice or from his own reading, or both, what he had to do.
Yes.
And that, in a sense, takes us back to the explanatory letter which came with the order, which the judge found to be readily comprehensible and appropriately accurate.
Yes, well, I accept that, but in all, with looking at all of the detail together, picking out that one without knowing, we know the letter was sent to Mr. Turk,
Yeah.
But no more than that. There was no record of the solicitors discussing it with him, and the lordship will readily know what's the extent to which those who receive solicitors' letters sometimes read them. And then there needs to be some kind of instruction stating. Yes, and I'm reminded helpfully that, of course, the letter, that letter predated the Shepherd email, and
Yes.
So that if, as he should have done, his lordship accepted what is set out in the Shepherd email, it's clear that it was not in fact understood. Can I now, if I may, just turn briefly to 286? Your lordship is quite right that he does refer to that submission which I made in written final submissions. He says, in particular, I've taken into account the absence of any positive record of explanations given. In an ideally ordered piece of litigation, there would be attendance notes of all meetings and all advice given. Well, that's true, of course, but there are none here at all. In this case, there is little of that kind of document. And he sets out Mr. Litovchenko's notes, which are, to put it mildly, difficult to decipher. I've also borne in mind Mr. Counsel's submission that Mr. Turk would have been taking a great risk in waiving privilege and seeking his former solicitor's papers if he had been advised of his obligations, because he ran the risk that that would be clearly disclosed. There is something in this point, but it's not determinative, and I do not consider it raises reasonable doubt when placed alongside the analysis and probabilities I've set out above. Well, we do say that that was significantly to underestimate the importance of that point. This is not a case of somebody who, armed with his former solicitor's files and knowing what they contain, takes the deliberate decision to waive privilege. This is quite the opposite. This is a case of somebody who does it without knowing. And the risk there of something being revealed, if advice had been given, would be almost overwhelming. The judge repeatedly referred to the fact that the appellant was a businessman who would understand documents like the order of which he was alleged to be in breach. This completely, in our submission, fails to take into account the effect of his disability, but can I deal with that in ground 4? can I move on, because I'm very conscious of the time, to ground two, continuing obligations. Paragraphs 30 and 31 of his judgment, his lordship's judgment, which is at page 160, are the two paragraphs where he's dealing with this issue.
Sorry, 160, did you say?
Yes, page 160 of the core
Page
bundle. Two paragraphs at the top of the page.
Yes, yes.
Can I come to those in a moment? The judge in our submission entirely failed to, or certainly didn't properly address the issue of whether or not the appellant's obligations of disclosure were continuing or time limited. And so failed to assess the question of contempt and indeed contumaciousness.
Well, you've got three obligations. The obligation to give information, quote, forthwith. Everybody seems to agree. That means as soon as is reasonably practicable. You've got an obligation to provide written information by a fixed date.
Yeah.
And you've got an obligation to provide an affidavit by another fixed date. When do you say the first obligation
Insofar as the
should have been, was required to be complied with, bearing in mind that if you are required to disclose information, you may have some of it to hand immediately. You can do it within an hour or two. Some of it you may need to look something up or confirm something, or possibly even ask somebody else. So it's not like doing a single thing by a single time. You've got a process here, at least potentially a process, of disclosing different bits of information. So when do you say that Mr. Turk was required to comply with that obligation?
By what is said in the order, paragraphs 16 to 18 require him. Now, the time limits may have been completely unrealistic, but that's not the fault of the appellant.
So you say that forthwith means by the, was it 16th of March?
Yeah, and within 48 hours means within 48 hours.
Well, that I follow, but it's what forthwith means.
Yes, I do. I say it means certainly by the time of the return date. Now, to answer your lordship's point, if I can, those are the words chosen by the respondent.
Yeah.
And it's, one might think, an extraordinarily short period of time to give someone the opportunity of responding. And of course, I suppose there are ways in which that problem can be mitigated, such as asking for more time. But that didn't happen in this case, with respect. At least he wasn't given more time until the return date, and that was only in relation to the paragraph 21 obligation, which we say it goes to a different obligation. If I come to that in a moment.
Well, paragraph 21 is not one of the breaches alleged.
No, it's not. It's an obligation to verify by affidavit.
Yes, there's no allegation of breach of paragraph 20.
So we do say, and if I might just expand upon that a little bit, in paragraph 43 of our skeleton, we set out the decision of Sir James Munby and Reed Jones, which was a family case. You'll find it at page 801 in the authorities bundle, so in volume 2.
This is in Kia, we'll have it separately.
It's in, you're quite right, my mistake. It's in Kia, it's referred to Reed Jones. And it's
yes.
It's the
round about paragraph 71.
Excuse me, I'm in the wrong bundle. If you'd give me a moment. Yes, if you pick it up, it was a family case in which the respondent was required to deliver up her children at Cardiff railway station no later than 4 p.m. on the 12th of October 2012. She didn't, and for reasons which are not entirely clear, contempt proceedings were begun first in relation to that failure, but also alleging a continuing breach thereafter until the 17th of October, when she and her children were found by the police. Sir James Munby dismissed that latter allegation in what was described by the court in Keir as characteristically trenchant terms. In paragraph 20, he says, in reading from the fifth line, it did not as a matter of express language require her to do anything at any time thereafter, nor did it spell out what was to be done if, for any reason, there had not been compliance by the specified time. In these circumstances, there can be no question of any further breach, as alleged in the application. And then, picking it up, if I may, on the next page, at paragraph 72 of the judgment in Keir, Lord Justice Nugent makes the observation at the beginning of that paragraph. At first blush, it comes as something of a surprise, because it's an everyday experience to regard and refer to a person who doesn't comply with an order as being in continuing breach. It's therefore easy to slip into the assumption that a person who is in continuing breach is also committing a continuing contempt. And then if I may miss out the next bit and read from the next sentence, but the logic of Sir James Mumby's decision is impeccable, and I have no hesitation in accepting it, and in accepting that it is in fact heretical to think that a person who has continued not to comply with a mandatory order after the deadline imposed by the order is committing a continuing contempt. A contempt in failing to do an act by a particular deadline is committed, if at all, when the deadline is not met, and failing to do the act thereafter is not strictly a further or continuing contempt.
Is there a continuing obligation, though? Leave aside contempt for the moment. Is there a continuing obligation, or can somebody in Mr. Turk's position say, well, I was supposed to comply with this by the, whatever it is, the 15th of March, I didn't, and that's it, I don't need to do any more?
My submission is that there isn't, strictly.
Doesn't need to do anything more?
Continuing, well, no. According to the wording of the order, that was when he needed to do it.
Yes, I'm
certainly.
I'm trying to distinguish, if there is a distinction, but perhaps there isn't, between the breach of the obligation, which may be a continuing obligation, and the contempt.
Yeah.
So is there, you say there is no continuing obligation?
Well, of course, in this case, there were other obligations, but...
well, but they were by specified dates.
Yes, I do say that is the case. It may seem...
There is contrary authority, which I don't think we've been referred to, but there is contrary authority.
Well, in my submission, it follows, it's a matter of logic, that there can't be a continuing obligation. It may seem odd, and certainly Lord Justice Nugent expressed some surprise at that. But
you would say it would be addressed by having additional words. If not, then whatever. And if you're required to do something by a date and forthwith you submit, incorporates, or you have to identify the date by which you have to do it. And if you haven't, you're in breach. What you do thereafter might be a mitigation of the breach if you do subsequently provide the disclosure required.
Yeah.
But it's not every day you don't do it isn't a further contempt or a further breach.
But your Lordship is quite right. There would be nothing to prevent the author of the order from inserting words like "or as soon as reasonably practicable."
Well, that's what it means. Everybody agrees that that's what this order means.
Well,
other words. But technically,
I think it's if not, because if your submission is as soon as reasonably practicable, you still have to identify a date by which the judge is determining whether there has been a breach and whether there has been a contempt.
you do. And your Lordship has already referred to the fact that this is a case where the applicant relied upon breaches of paragraph 16 to 18 of the order. So I make that point because at paragraph 30 of his judgment, going back to the core bundle, it's at page
In paragraph 30, isn't the judge really saying that he's interpreting as soon as reasonably practicable to mean by the 22nd of March? Because by that stage, he goes on to find Mr. Turk knew what he had to do enough and hadn't done it. And what one needs to bear in mind that the reason why the judge found Mr. Turk to be in contempt was not that he achieved the full level of disclosure, this is at paragraph 296, that he hadn't begun it.
My lord, I do submit that isn't, with respect to what the judge is saying in paragraph 30. He's referring to forthwith, which he says means as soon as reasonably practical, 48 hours, applicable to paragraph 18. So whatever else one makes of it, the paragraph 18 obligations end after 48 hours. He then refers to a different obligation, namely the requirement for an affidavit setting out and verifying the disclosure information is to follow within 5 working days. And then, skipping a sentence or two, he says, I agree with Mr. McCourt-Fritz that that is the most important date by reference to which one has to assess whether there was a breach or not, though one must not lose sight of the fact that there was a prior obligation to make less formal disclosure under Miles J's order in relation to the obligation to disclose material forthwith. So he's drawing a distinction there in my submission between the paragraph 21 obligation, which was then extended, and the prior obligation to make less formal disclosure. And he's relying upon the fact that there was an extension to the paragraph 21 obligation as fixing upon what he describes as being the most important date by reference to which one has to assess whether there was a breach or not.
Yeah. So you say that when he says prior, that must mean before the 22nd of March.
Yeah. Yes.
And therefore, if one's considering breaches of paragraph 16, 22nd of March can't be the right date.
Yes. With the greatest of respect, in paragraph 40 of the learned friend's opening skeleton argument to the court, I'll just give your lordship the reference. It's a supplemental
Skeleton
bundle.
in this court or below?
Below.
Below.
Supplemental bundle, tab 7181. It said that the disclosure obligations contained in paragraphs 15 to 20 of Miles J. order are the basis for the committal application, so that's fairly self-evident. And on the return date, so on the 18th, the respondent, through her counsel, invited the court to consider making directions for a hearing at which the court would be asked to consider exercising its powers of its own motion to commit. So the respondent's case, by the return date on the 18th, so before the dates that we've been looking at, was saying at that point the court should consider whether or not to exercise its own motion powers to commit. And nor would, with respect, counsel have been telling the Deputy High Court judge at the return date, this was the 18th of March, of course, and to find this passage, your lordship would need to look in the additional transcript bundle. Might I just give your lordship the reference for now, unless you want to see it? It's four lines, and I can read it.
Just hang on a minute, I'll put a sticker in it. Oh dear, that's one of the bits.
Shall I take your lordship to it?
What page?
It's at page page 46, electronic page 46, and I hope it's numbered. It's got 3 page numbers. The larger number is CB346, if that helps.
Yeah.
And at the top of the page,
Yes.
perhaps I could go back to the
Time for
bottom of the
compliance
page.
gone, long gone.
The time for compliance with the forthwith and immediate obligations is obviously long gone. And the time for compliance with the paragraph 18 obligations, 48 hours after service, expired on Saturday evening. And here we are on Thursday afternoon, my lady. but Mr. Turk says he has complied. Can I move on, to ground 4, because of course ground 3 isn't proceeded with, save that it provides some support to the other grounds. The effect of the appellant's ADHD, well-documented difficulties. The court had a psychiatric report from Dr. Gupta and a report from a court-appointed intermediary. As is, I'm afraid, the way of these things, the intermediary that had prepared the report was not one of the intermediaries who helpfully attended at the trial. The intermediary who did, for most of it at any rate, was somebody called Catherine Stewart, who was extremely helpful. The recommendations in the report, or the conclusions in the report, was that Mr. Turk's memory is affected by his limited ability to process lengthy information. Can I just give the Lordship the page reference from Supplemental Bundle, tab 9, 257 for that. He struggles with day-to-day memory and remembering important information, that's 261. His comprehension is impaired, and when he's given too much information at once, when his auditory working memory is overloaded, he can't understand, that's page 263. And without visual prompts, he can remember only 3 what are described as information-carrying words, compared to the average adult processing of 6 to 8. Crucially, we would submit, he may appear to be listening and indeed understanding, but in fact is disassociating. And that's in the Supplemental Bundle, tab 9, page 257. He'd suffered from that condition since the age of 7. And as his Lordship rightly referred to, those difficulties with concentration had been noted by his former solicitors Bivonas at a very early stage, although I'm not sure that they were aware that he was suffering from ADHD. There's an email from Mr. Litovchenko to Mr. Quirk, where the former recounted how he tried to go through a list of topics with the appellant, but how it had been incredibly challenging, and how the appellant had told him that he needed to read them carefully, but he loses attention frequently and sidetracks. So that disability affected 2 things which were important to this case. First of all, of course, his ability to understand the order, and secondly, his ability, his capacity to engage in the legal proceedings itself. And the intermediary's report made a number of recommendations, the most important of which were, first, that he needed to be given time to process information and assistance to understand and respond appropriately. He would need intermediary assistance throughout the court process. Any breaks should be long enough to allow him to leave the court building, and there should be a break every 45 minutes to 1 hour. All questioning of him should be by way of short and to the point sentences, and that, importantly, cross-examination should be concluded in 1 day. I do say with the greatest of respect that the trial effectively proceeded without there being any meaningful compliance with those recommendations, largely because the judge felt able to rely upon his own observations of the appellant. Example of that, we'll look at 1 or 2 more in a bit. Paragraph 280 of his judgment. And effectively...
Well, is that really fair? I mean, if you look at the transcript of the ground rules hearing, suggestions are put to Miss Stewart, who by then was acting as the intermediary. She keeps saying, that's fine, that will assist, yes, that's fine, that's fine. The only recommendation which the judge doesn't adopt is that Mr. Turk's evidence should be confined to a day, because he says it's not fair to either side.
Might I take, Your Lordship, in just a little bit more detail.
You go to page 287 in the supplementary bundle. Manuscript page 32. The judge is beginning to summarise, and then the judge says, "Is there anything else you want to raise?"
Yeah.
Ms. Stewart says, "Evidence over 1 day." And you are in agreement with that. Mr. Fritz says no, and then the judge says, "Mr. Turk must have the opportunity to explaining that which Mr. Fritz claims needs explaining. And if cross-examination is too short, and Mr. Fritz can't put his case properly, which means I won't have heard Mr. Turk's side of the case properly." So he's effectively saying it's not fair on either side to accept that recommendation, but everything else seems to be pretty much agreed.
Well, can I take your lordship in a little more detail, if I may, to that transcript, beginning, if I may, at page 25. So line 19, Ms. Stewart says, "Yes, most of what I propose are already in the report. Recommendations about speaking slowly, speaking simple language, giving time for Mr. Turk to process what's being said, so not giving a vast amount of information in one go. The biggest part is about having breaks. From the assessment, he was assessed for an hour and a half, and after 40 minutes he requested a break. I would say at the moment 45 minutes is a basic basis to stick to, so every 45 minutes for about 15 minutes. That gives him time to have a break from processing where he can go outside completely on his own, not speak to anybody, and then have time with myself and his legal team to check that he's following the proceedings." And then Sir Anthony says, "You're the closest thing we have to an expert in this case. In fact, you are an expert in this case. And I don't know how these things work, but it strikes me that 15 minutes every 45 minutes is longer than one would normally expect. 15 minutes is a long period of time."
Yeah, and then he goes on with that. Then he finishes by saying, "Does that fill you with horror?" Ms. Stewart says, "That's fine."
Yes.
There's a massive miscommunication. He's got confused. I wanted to talk for a quick break.
Yes.
Then Sir Anthony says, "Well, you can't really speak to your lawyers while you're in cross-examination." But then he goes on to say, page 28, if you see there's a problem, it's the equivalent of what you describe in your report as putting a hand up. Mr. Turk's represented, intervention should come from you. You can have your input. Ms. Stewart, that's fine.
Yeah.
And so it goes on.
So far as Miss Stewart's recorded acceptance of what was being suggested, I think what Sir Anthony was saying was, this is what we're going to do. But there'll be a little bit of leeway. The 45 minutes, it'll be 45 minutes to an hour.
And the discussion goes on, and then at 39, manuscript 39, line 8, he says, "I think we've established the ground rules, have we not? Questions will be short and simple. You, that is Miss Stewart, will speak to Mr. Fritz about the nature of the questioning. There will be breaks, which will be around the hour mark, for probably about the 10-minute mark. We'll see where we go. You'll be here all day. You are to raise any concerns from Mr. Counsel. Sit yourself where necessary. Did we do anything else? I don't think so. Right, those are the ground rules." And that's the end of that discussion. And that's what happened.
Well, forgive me, my lord, that isn't with respect to what happened, because actually when it turned out, for example, the court sat for a good deal longer than an hour on a number of occasions. On one occasion, to finish, for
Yes,
4
you said
hours,
4 hours, yes.
with 2 5-minute breaks. Whilst I entirely accept that Sir Anthony, no doubt doing his best, was turning for help from Miss Stewart, she was to an extent put on the spot a bit when she said, "This is what I'm going to do. Is that right? And if it isn't, you raise your hand," or whatever it might be. And the reality here is that on a number of occasions, having set those ground rules, the judge failed to follow them.
Was there any objection at the time?
Well, to an extent, if I can I just pick that up? Forgive me for a moment, just find my place. Can I just give you one example? And I'm afraid it does mean taking you to the additional transcript bundle, so the grey file. Please, this is an interjection by me. And the this is day 2. So it's coming to the end of Moylan and Friends opening. No, it's not. It's in the middle of Moylan and Friends opening, and we were right at the end of day 2, and on internal page 281.
201.
Internal page 281, page 107. 281.
Yeah.
Bundle page 107. I say at line 11, which brings me on to something I was going to raise with your lordship. That will mean we will not be starting Mr. Turk if he gives evidence until after lunch. So this was Friday lunchtime, effectively. And of course, we may have some submissions from me on admissibility, together potentially with some cross-examination. I know Mr. Turk is very anxious. We have not made a final decision yet as to whether or not he'll be giving evidence. We're very anxious at least to know when that is likely to be. I'm not going to give any indication now. Depends how quickly we go tomorrow. I'm going to review where we are now and decide how much more of this I want to have done. It's not helping me quite as much as I thought, but it is giving me some assistance, but we will see. We may, to that extent, be a little quicker tomorrow. I'm not going to give him the assurance he needs at the moment. I think he can be satisfied that if we end up at 3:30 on Friday, and that would otherwise be when we would reach him, if he is to be reached.
This presumably is the Thursday that this discussion's taking.
This is late on Thursday, yes.
Yeah.
And it's the usual inquiry. Is your
Yeah.
lordship going to want to hear from the defendant or whoever it might be, starting at lunchtime or whatever? Going on, if I may, he's unlikely to be called upon to go into the witness box for 3/4 of an hour. If it's something like half a day, he might be. I don't know. We will see where we are, Mr. Counsel. And then I say, with the greatest respect, my lord, I know from speaking to Miss Stewart that she's already expressed some concerns about his evidence going over the weekend. And there was a passage in the part of the transcript which your lordship clearly has read, where she raises concerns about splitting his evidence. We will cross this bridge when we come to it, Mr. Counsel. I'm not going to give any assurance now. We will cross the bridge when we come to it. I'm sensitive for any witness, frankly. And then I say, I hope not impertinently, yes, but this is not any witness. And then Sir Anthony Mann says, just a minute, I'm sensitive for any witness not to necessarily put them in an unfair time in the witness box when they're going to be in purdah with all the difficulties and so on and so forth. But I'm certainly alive to his problem. But I'm not going to give any assurances now because I do not know what the position is going to be tomorrow. I'm being as kind as I'm required to be to Mr. Turk. I stress his psychiatric position relates mainly to focus and not to over-anxiety. I'm sure he is anxious about this. Every witness is going to be, every client is going to be anxious. He's not to that extent in any different position from other witnesses. I just give that as an example that it is a difficult position to find oneself in. Obviously, one has to do one's best for one's client, but the difficulty about raising it, every time there appears to be some difficulty on the part of Mr. Turk about understanding a question, is that not unnaturally, the trial judge may think that counsel is trying to protect his witness. I try to do this through Ms. Stewart as much as possible. Essentially, Ms. Stewart was neutral and independent in the middle, although, of course, she was there and did do her best. But Sir Anthony had relied upon his impressions to a great extent, and he had set the ground rules, and with respect, he didn't follow them. Would your lordship give me a moment just to check that I haven't missed anything important on this ground? Yes, I'm not going to take your lordship to it, but at paragraph 58, he set out a list of a number of occasions where the judge effectively makes observations about, records his observations of Mr. Turk.
Yes.
And I'm not going to take your lordship through all of those. And then at paragraph 62, we refer to the case of Solanke.
Yeah.
That was a case where the judge had refused an application to adjourn a trial made on the basis that the defendant was not well enough to attend because of his mental health. The trial proceeded in his absence. The defendant's defence was struck out, and the judge gave judgment for the claimant and refused a later application to set aside. The judge had been provided with what he described as a comprehensive letter from a GP as to the defendant's mental health difficulties, which concluded that the GP had concerns as to whether he was medically fit to be able to represent himself. Court of Appeal allowed the appeal on the basis, first, that the judge had failed to give proper reasons for his decision, and secondly, because the judge rejected the doctor's view on the basis of his own observation of the appellant in court. And I do say, with respect, that Sir Anthony Mann did the same, and that this was not a case. Symptoms of ADHD are not straightforward, and the difficulty with a condition such as that is it is not immediately obvious, even to the person suffering from it, when he's not understanding, the judge overlooked that point. Nowhere in his judgment does he say, I've taken into account the fact that those suffering from ADHD sometimes either consciously or subconsciously can conceal the condition and the difficulties that they're having. Can I move on to ground 5? The judge's approach to the underlying proceedings, and perhaps take this shortly. It's often the case, of course, that contempt proceedings are being brought prior to the resolution of the main proceedings, as here. And it's often the case that the court can be faced with a particular difficulty of being asked to make findings to the criminal standard on issues which will then be rerun with the benefit of all the evidence available after disclosure and exchange in the main proceedings. And where there's a dispute of fact, the courts have repeatedly emphasised that the correct place for the determination of things like the veracity of statements is at trial, where all the relevant issues of fact are before the court, and as here, all the parties are there, and the court has all the evidence.
Well, Daltel and KJM, I can't remember TBD, they were both cases of applications under Part 32. They weren't applications based on breaches of court orders. That was to do with knowingly making a false witness statement.
Yes. So
there you can see that deciding whether a witness statement is or isn't false in advance of the trial is plainly an overlap.
I agree.
Whereas breaching a court order may not overlap. Particularly whereas here what we're talking about is disclosure of the whereabouts of assets. Mr. Turk's defence that Mrs. İŞBILEN, if that's how you pronounce her, authorised all these transfers is neither here nor there on the occasion.
With respect to it was important to this case because if the judge had concluded that she had authorised all of these transactions, then that goes to two issues. One, contumaciousness, and secondly, to the existence of harm, if she was aware of all of this.
I can see it goes to the second, if you knew all about this already, but I'm not sure that it goes to the first one. But it's not an issue overlapping at trial. You know where these assets are.
That certainly isn't. But the issue of whether or not the defendant was making it up, as the judge concluded, say the appellant was making it up when he said that she gave authority for and indeed signed some of these transactions, was an issue which overlapped between committal trial and the trial itself. I take on board the point that Moylan firm will no doubt make, which is that the defence relating to the Hawali payments, as they were known, was raised rather late in the day because although Mr. Turk said that he had in fact raised it with his former solicitors, they found their way into his statement. But that was a statement served upon the respondent in August of last year, so some time in advance of the trial.
I mean, there is a slight oddity about Hawali payments because the judge said that even if they were Hawali, Mr. Turk still hadn't complied with the order. So, in a sense, it was unnecessary for the judge to decide whether they were or they weren't.
Well, he did, and what he went on to do, of course, was to draw conclusions about Mr. Turk, which were distinctly unfavourable. He described Mr. Turk at paragraph 63. He said those inaccurate documents are not the mark of an honest man. And he then concluded at paragraph 171 that the explanation which he'd given was a fabrication, and certainly in relation to count 3, that the breach was more egregious as a result. So he did reach those conclusions, and in our submission, he should not have done so.
Mr. Campbell, can I ask a sort of fairly basic question, please? To what extent, if any, would findings made on the committal bind a judge at trial?
I'm sorry, my lady.
To what extent, if any, would findings made by the judge on the committal application bind a judge at trial?
Gosh, that's a...
Well, I just ask because it seems to me to be potentially relevant.
Yes. In my submission, they wouldn't, because for the same reason, which is that at trial, the judge is likely to be dealing, particularly in a case like this, with a good deal more evidence.
Exactly. So what's the principled objection to the judge making findings on the committal application on the basis of the evidence he has got?
Because he made findings on very limited evidence.
That's a different question. That's a different point.
Well,
Your submission under this ground is he shouldn't have embarked on the exercise at all.
Yeah.
Not that he didn't have enough evidence to reach the conclusion.
He shouldn't have embarked upon it because he didn't have enough evidence.
Yes, I see.
That's the danger, and it's the danger referred to in it's wrongly cited as JSC, BTA Bank, and Solodchenko. It should be that bank and Ereshchenko, where the Court of Appeal it says at paragraph 63, this is authority bundle tab 14 at page 598. And it's referred to in our skeleton at paragraph 64. It seems to me, they said, that it was...
14.
I do apologise. Tab 14, page 598.
Yes.
Paragraph 63. It seems to me, the court said, I think it's Lord Justice Lloyd, that it was entirely legitimate for the judge to regard to both of these factors and to be cautious in his approach to the fact-finding process arising on the committal application because of those factors. He then goes on, of course, because of the need to apply the criminal standard proof. If the judge was in any doubt, the bank couldn't make out its case. So it's not a question of giving Mr. Ereshchenko the benefit of any doubt. he had to have that in any event. But it was fair and proper for the judge to take these points into account, and considering the evidence as it was put before him, and deciding whether he was left in any doubt. I don't want to make too much of this point, but in my submission, as your lordship has rightly said, he didn't need to do this. What he was dealing with was the issue of what's happened to the money and the failure to disclose what's happened to the money. Instead of that, he was invited to become sidetracked to deal with what.
Well, let us suppose, for argument's sake, that you're right about this point. But that the judge was entitled to say, well, even if they were Hawali payments, there was still a breach because additional information should have been disclosed. What do we do?
Well, allow the appeal. Or if it goes only
On everything?
No, it's specifically in relation to some of the counts. It's count 3. I often get muddled as to
Yes,
which count
but the judge found that even if these payments were Hawali, as Mr. Turk said they were, there was still a failure to disclose what he should have disclosed.
Yes. Yes. It certainly goes, can I reflect on this perhaps, but it certainly goes to the question of sanction.
Yes.
Perhaps I could think about that and come back to your lordship on that point, which hadn't occurred to me and should have done. There's another distinct point which is similar, which is referred to in paragraph 74 in our skeleton, and that is the evidence which he relied upon, which was before him in the summary judgment application. In October 2023, so shortly before the trial, the judge had an application over, I think it was 2 days. We on this side of the court were not there, because of course legal aid doesn't extend to this, for summary judgment against the appellant and others in respect of some of the grounds of the respondent's claim in the main proceedings. The judge, in fact, dismissed the summary judgment application largely, but in the contempt judgment, he took into account the evidence which he had heard at that hearing, and again made adverse findings about the appellant's credibility, commenting in this case adversely on the appellant's apparent failure at that hearing where he wasn't represented to contradict an assertion which had been made by the respondent. And if you, in the judgment, turn to paragraph 165, so this is core bundle, page 198.
Yeah. Well, I mean, all he's saying is that if these were Hawali payments, Mr. Turk might have been expected to raise it quite earlier. And it's not what his defence pleads. It wasn't raised by him at the summary judgment hearing. Yeah. But that's all he's saying.
That is all he's saying, but that's not an inference in my submission which he should have reached, given Mr. Turk was not represented. Although I think at that hearing, because we wrote to the court, he was aware of Dr. Gupta's evidence that he was suffering from ADHD. We didn't have an intermediary report, which was much later. And with respect, it's an inference which he should not have drawn. Ground 6, liability as a director. Again, 2 points in relation to this ground. First of all, 6A, requirement of appeal notice. He deals with this, just to give your lordship paragraph numbers at 64 to 79 of his judgment, which I'll come back to. We've referred in our skeleton to the test in Iberian Trust, set out by the court in that case, which stresses that in the order so served should, as a preliminary to its enforcement against the directors, be endorsed with a notice to the effect of the memorandum prescribed by the order then in force, including in it the name of the particular director served, and makes the point that, as far as my experience goes, this has been the practice in the Chancery Division. Then coming forward in time to Masry, the judgment of Mr. Justice Blair, who followed that approach. Again, I'm reading from the extract in our skeleton. The judge held, thus the rule does not require an individual director to be named. Although not required by the rule, there is authority that as a matter of practice, the order served should, as a preliminary to enforcement against the directors, be endorsed with appeal notice, including in it the name of the particular director served. Mr. Justice Blair refers to Iberian Trust. We then refer to current CPR, a prominent notice on the front of an order. In fact, this being notice was trickled over onto page 2, but I don't take that point because there was authority which suggested that wasn't good enough, but I think it's no longer. A prominent notice on the front of an order warning that if the person against whom the order is made, and in the case of a corporate body, a director or officer of that body, disobeys the order, the person or director or officer may be held in contempt of court and punished by a fine, imprisonment, confiscation of assets, and so forth. And then in 81.4.5 of the current White Book, the 2024 edition on page 2406, a suggested wording is set out. Looking at paragraph 2 of that, if AB Limited neglect to obey this judgment by the time stated, you, XY, director or officer of the said AB, may be held to be in contempt of court and imprisoned or fined, or your assets may be seized. So, two aspects we would submit. The appeal notice should include reference to the director to whom notice is to be given, and it should alert that director as to the potential consequences. Now, the appeal notice in the Miles J order, in our submission, doesn't do that. If you turn to the supplemental bundle, right at the front, or very nearly at the front, to page 4, top of page 5, bottom of page 4, I'm sorry, I'll pause.
Yes.
Bottom of page 4 sets out appeal notice addressed to Mr. Turk in his personal capacity. And then at page 5 at the top, if USG Financial Group, Barton Group Holdings Limited, Sentinel Global Asset Management, and or Sentinel Global Partners, disobey this order, you may be held to be in contempt of court and be fined or have your assets seized.
When you said that the first sentence is addressed to Mr. Turk in his personal capacity, what did you mean by that?
Well,
it's just addressed to Mr. Turk. Never mind what capacity it's addressed. He's holding.
well,
It's saying if you, Mr. Turk, know this stuff, you must tell us.
yeah, if you're in contempt of court, and then sets out the consequences.
Yeah, but the as the judge said, when you get to paragraph 16, it's an order against Mr. Turk.
In my submission, what is required, as is set out in the current version of the White Book, when dealing with the second part, is that it should be made clear that the director should be named and he should be warned as to the consequences. And that second part doesn't do either of those.
Well, that depends on whether he's being punished for his own breaches or the company's breaches.
Or in his...
If you go for a moment to paragraph 15.
I'm sorry, my lord, I missed.
Go to paragraph 15 for the moment.
Yes.
That's the freezing order.
Yes.
And I can see that if one of the corporate defendants had disposed of an asset that was frozen by that order, then Mr. Turk would not be liable for the company's breach unless he had been named in the penal notice. I see that argument, But when it's a question of revealing what he knew, which is what paragraph 16 is all about, why is the judge wrong to say it doesn't really matter in what capacity he knew it?
Well,
He personally, never mind the company, he personally was required to disclose it. And that is what the application notice says repeatedly. He knew this and didn't disclose it. He knew this and didn't disclose it.
Well, yeah, but he's being held liable in his capacity as a director.
Well, that's why I say, what do you mean by in his capacity? He's being held liable for his personal failures to disclose information which he acquired, maybe as in his capacity as a director, but it's within his personal knowledge.
If he's being held liable in his capacity as a director, then he must be told what are the consequences.
Well, I'm not sure I follow that. What the penal notice is all about is being held vicariously liable for a breach by the company, not your own personal liability. It's like that old, I can't remember the name of the case now, that went to the House of Lords about the fraudulent misrepresentation made by a director of the company. You can't say, well, I only made this fraudulent misrepresentation on behalf of the company, so I'm not liable. Yes, you're personally liable.
Yes.
That's what the judge is deciding. Williams.
Can I just give you an example? If your lordship would turn to the core bundle,
Yeah.
At tab 14,
Yes.
page 273.
274.
273. At the directions hearing before this trial, the respondent was required to set out in more detail what their case was, and they do so. And just by way of example, let me turn to what is said against SGP. So this is count 4, which begins at 273. What is set out there is provisions of the Miles J order allegedly breached. The first one is that he's in breach of paragraph 16, 1 to 4, in his capacity as a director of SGP. And there are a number of others. Your lordship will find them set out in various different parts of this document. On some occasions, he's in breach in his personal capacity, it's said, and some in his capacity as director of SGP, of Barton, and of AET, I think. And on one occasion, so far as AET is concerned, it's pleaded that he was in breach in both, in his personal capacity and in his capacity as a director of the company. So
he's not a director of AET, and that's not our case.
When I said it, I thought, no, that's not right.
Sorry?
He's not a director of AET, and that's not our case. It has nothing to do.
So far as AET is concerned,
Sorry, is your submission that he was being, the committal application was in respect of breaches by the companies, respectively, of their obligations? Is that what you say the words in his capacity as a director of?
Yeah.
What those words mean?
Yes, it is my submission. In fact, I'm going to come on to say the judge overlooked the fact that in certain respects he was dealing only with Mr. Turk's an alleged breach by Mr. Turk in his capacity as a director, so vicariously.
But if you go back to tab 13, page 264. If you go back to tab 13, page 264, which is the application notice, this is all about what Mr. Turk knew. It's not saying the company failed to do this, that, or the other. It's saying that Mr. Turk knew this and didn't disclose it.
But he's also knew it in his capacity as director. Because there's a different test, I'll come on to that. A different test applies for somebody who is alleged to be in breach, alleged to be in contempt in his capacity as a director.
But do you rely on the words and or cause Barton and Sentinel to fail to disclose?
Yeah.
At the beginning of paragraph 12, in the committal notice, which would suggest it was breaches by the companies of their respective obligations.
Yes. It's certainly not. My understanding it always was that the allegations against him were both in his personal and in his capacity as director of various companies. Doesn't apply to all of these allegations, but certainly some of them. And I do say that in those circumstances, this penal notice failed to comply with CPR Rule 81. And the fact that he was, of course, also involved in these proceedings personally, and as we've seen, was subject to a penal notice specifically addressed to him, doesn't, so to speak, let the respondent off the hook, makes it even more important rather than less to ensure that the penal notice is clear that he can be held liable for breaches of obligations by the corporate defendants. My Lord, we've referred to the case of Novan's Jets, Olympic Council of Asia, and Novan's Jets, a decision of Mr. Justice Foxton, where one of the orders, there were two, there was one described, this is Authorities Bundle, tab 31, page 1033 is picking it up, if I may, in the middle of the judgment. 1033, the judge sets out the wording of the penal notice of what he describes as the April order. Forgive me, it's Authorities Bundle, page 1033, tab 31, which is in your last volume. And at paragraph 13, Mr. Justice Foxton sets out the wording of what he described as the April order. He uses that expression because there was a later order which was challenged for different reasons. Again, there's no reference to the name of the director. Although, in fact, in that case, there is reference to the fact that the person can be imprisoned. Going back, if I may, to the core bundle, to the judge's judgment and how he deals with this at paragraph 74. So that's page 172. He first of all explains at paragraph 73 why he doesn't consider that he's assisted by the Iberian case. And then at paragraph 74 he says, properly read, it is plain that the disclosure obligations in paragraph 16 were directed at Mr. Turk in whatever capacity he might have held the knowledge. The idea that he could hold knowledge or gain knowledge as director of one of the companies, but could somehow say that he was not obliged to disclose it because there is no particular reference to him as a director of that company, is rather absurd. One way or another, the order in that paragraph is directed at him, and there's a penal notice directed at him, which makes plain the effect of non-compliance. That makes sense in the context of an action which is based on the fact that he was a person entrusted with the claimant's money, and which is based on the premise that the respondent does not know what has happened to it. Mr. Turk does or should. In my submission, that is not to draw a proper distinction between the different requirements set out. This penal notice, insofar as it was addressed, insofar as it was dealing with corporate defendants, should have named him personally and should have, but but did not, made it clear that he could be liable in his capacity as a director to go to prison, and it did not. Also, the judge was also wrong to conclude that he did at paragraph 77 that any shortcoming could be cured by a waiver of the requirement. There was no application made by the respondent to waive the defect, and there was no evidence to support the finding that the appellant was not prejudiced and that the issue didn't affect his compliance. Indeed, he was asked about that in re-examination, and his evidence, this is was at day 8, it's in the supplementary bundle, tab 14.116. I asked him, when you read that, to who was that directed? Can I, supplemental bundle, tab 14.116.
I don't have tabs, so what page is it?
116.
Sorry?
No, it's not 116, forgive me.
My clerk's very helpfully put some tabs in my bundle. Tab 14 begins at 436.
Yes. Your Lordship, give me a moment to find the page. I, for some reason, haven't marked it.
Your re-examination starts on page 529.
Yes, thank you. Yeah, it's almost at the end. Page 551.
551.
Yeah. The last 5 lines. I've been asking him about the penal notice and the different parts of it. Perhaps I could pick it up. Line 18. Penal notice. If you, and then I read out the first part of it. Do you see that? Do you understand that? He says, I understand the first part. If you, Selman Turk, disobey this order, yes, I understand that part. And then I say, no, the second part. And then there's an exchange of half question and answers. Hang on, let me ask the question. When you read that, to whom was that directed? To which his answer, to companies. Why is that? Why do you think that? Because it says SG Financial Group, Barton Group Holdings Limited, Sentinel Global Asset Management. That's why, and of course it does.
I'm so sorry, it's my fault, Mr. Counsel. I didn't have the page reference to that exchange.
551.
551.
551.
Lines,
Right at the bottom.
Lines 18 to 33.
Thank you very much. I briefly mentioned it already. Can I deal with this now? Test for director's liability. In our submission, the judge, in any event, so far as when he was dealing with Mr. Turk's liability as a director, failed to apply the correct test. In Attorney General Tuvalu and Philatelic.
Well, I think there's no dispute that that's the test.
Yes. Effectively, the judge in this case proceeded on an incorrect basis, that the position was the same, whether the appellant was in contempt for breaching an obligation addressed personally to him, or in breach of an obligation addressed to a corporate body of which he was a director. And that relates to, I won't take your Lordship to the detail, counts 3, 4 and 8, so not all of the counts. Your Lordship has the relevant test in page 127 in tab 3 of the authorities bundle, which makes clear that unlike in relation to personal liability, there is an obligation only to take reasonable steps to ensure that the order is obeyed, and there must be culpable conduct. So mere inactivity isn't sufficient. There must be a failure, I'm reading from page 129 of that judgment, to supervise or investigate or willful blindness. So knowledge of the order in the case of liability of a director is not sufficient on its own, irrespective of whether I make out the points we made in ground one. And with respect to the judge, nowhere did he address his mind to the need to ask that subtly different question. He doesn't refer in his judgment anywhere to the test in Tuvalu. What he in fact did was simply to elide the acts of, in this case, SGP and Broughton, with the acts of Mr. Turk. The judge's findings on SGP are at paragraph 74 of the court of ending.
So you said paragraphs. Paragraph
74. In fact, I've read this paragraph before. It's plain, he says, the disclosure obligations in paragraph 16 were directed at Mr. Turk in whatever capacity he might have held the knowledge. And then he goes on to deal with...
it's 75, isn't it, where he does CGP?
Yes, thank you. That renders debates about liabilities director somewhat academic, save insofar as it goes to the question of whether he should get information which he does not personally hold or have access to. So far as SGP is concerned, there can be no doubt that Mr. Turk was under an obligation to effect disclosure. The order says so, and the failure to identify him as a director is irrelevant. He's dealing with a slightly different point, but my point is that nowhere does he address his mind to the fact that there is a separate test in relation to his potential liability as a director, which involves an additional layer, so to speak, which does not apply to his liability as his personal liability. He comes back to SGP in much later in the judgment. Perhaps I should take your lordship to it at page 203. At paragraph 186. The breaches alleged in respect to these matters are a complete failure to provide the information required by paragraphs 16 and 18 of the order. And the ground summary says that the breach allegation is levelled at Mr. Turk in his capacity as director of SGP. Particular reliance is placed on the fact that as the search order fruits revealed, he had bank statements in his possession which would have allowed him to have provided the information if he'd forgotten precisely what it was. He himself admitted that he'd seen the bank statements, which he says he did not. He would have reminded of the necessary detail, which he did indeed admit when faced with the evidence. So far as Barton was concerned, Mr. Turk's position was that at the time that he was served with the order, he didn't know he was a director of Barton. Mr. Turk could not then, in our submission, have willfully caused Barton to breach the Miles J order. And the judge was wrong in paragraph 16. I'm sorry to talk about in the judgment. This is page 154. When he's dealing with the status of the corporate respondents, he says, so far as Barton Group Holdings is concerned, this is a BVI company of which Mr. Turk is and was the sole director and the sole shareholder. He claims not to have been clear as to whether he was a director at the date of the order, and contemporaneous privileged documents reflect that uncertainty, but says that his solicitors at the time investigated and found that he was. Then going down a little bit further, there was another director, but it's apparent that she played no active part in corporate decision-making, including the disposition of its monies. On this application, Mr. Counsel did not suggest that any uncertainty in his position as director should be treated as qualifying his disclosure obligations or mitigating any failure to disclose. With respect, we submit that the judge was wrong about that. Mr. Turk did not suggest any uncertainty in his position as director should be treated as qualifying his disclosure obligations. He completely failed in relation to that to address the different test which applies to director liability. My Lord, I'm done on ground 6. The remaining 7, fewer than that, 7 to 11, deal with sanction, which I
Yes.
think I can deal with in the half an hour which is left for me, unless you'd like me to start now.
I don't mind. If you want to stop now, we can start again at 5 to 2.
Well, why don't I make a start? Because the first one, ground 7, is similar to what I've already been submitting in relation to needing to adjourn until after the main proceedings. The first point that we make, ground 7, is that the judge ought to have adjourned these proceedings until after the main proceedings. He was wrong to proceed to sanction immediately rather than waiting for the conclusion of the main proceedings. And I've made the point already, there were overlapping issues here.
But why is that relevant to sanction?
It's relevant to...
I can see that your point is or may be relevant to his findings on liability, but if you're right about that, then probably sanction follows. But if you're wrong about that, why is it an independent ground to say he should have adjourned the sanction hearings, not simply for a day or two or a week or two, but until after the main proceedings? I don't understand that.
For two reasons, if I may. One, it goes to two sanction issues. One is contumaciousness, and the other is harm.
Right.
So far as contumaciousness is concerned, he made adverse findings against this appellant, in particular in relation to the Hawali payments, which we submit was an issue which overlapped between both. I've made that submission.
Yes, but he's found that already. By the time you get to the question of adjourning the sanctions hearing, all right, he hasn't found harm yet, but he has found deliberate breach. I don't use the word contumaciousness because I don't know quite what it means, but anyway, he's found a deliberate breach.
Yes.
So it's really harm. You say that,
it is.
that if Mrs. İŞBILEN knew all about this, then it doesn't do her much harm not to be told about it by Mr. Turk when she already knows.
Yes, and there was a certain amount of evidence. Of course, we've never been privy to what was going on in the main proceedings. We don't know what the 9 other defendants may have disclosed.
Yes.
If anything. Because
so really, what you're attacking is the judge's decision that there was harm. He didn't need to wait to find out. There was harm.
Yes, that's exactly right. He deals with it, first of all, in paragraph 4 of the judgment, where he says,
Yeah.
I'm looking at the wrong judgment, forgive me. Sanction judgment.
Yes, page 250.
I reject the submission that I've just made. The present harm is obvious. Mrs. İŞBILEN was entitled to have the information provided by Mr. Turk, and not receiving it from him was harm enough. Excuse me. She was entitled, excuse me. She was entitled to have the court order obeyed without argument and without having to wait until trial. And it would be inappropriate to wait so long when she was entitled to have the information at an interim stage. Now, that, in our submission, wrongly elides one aggravating feature, which was the harm done to the court by breach of an order, with the harm or prejudice done to a particular claimant. In every case of a breach of disclosure obligations, there will be harm, but the court's focus in our submission must be on assessing the extent of the particular harm to this claimant in these circumstances. And with respect, the judge was simply not able to do that. And if he had decided to do that, then he should decide the issue of harm in the appellant's favour. It's often said in these cases when dealing with sanction that there are two important features that a court needs to take into account. One is harm and the other is culpability. And in our submission, and this was a submission that we made, if the judge was going to proceed when the underlying proceedings were still extant, then he shouldn't make any findings adverse to the claimant. Instead of that, he did, as is set out in paragraph 4. Adverse to the appellant. Adverse to the appellant. I think I said something different. One last point. The judge plainly had in mind flight risk. Indeed, it's plain in my submission that he approached the question of adjournment by reference to the concern that he had. That, in my submission, was the wrong approach. There really was no evidence of flight risk in this case. This appellant had attended every hearing, including the very early hearings, the return date and so forth. He'd attended the summary judgment hearing on his own. He didn't have a passport. The evidence was that he was someone who could not leave the country, let alone go to Turkey, because of the political situation in Turkey. He was not a flight risk, and if that formed part of the judge's decision not to adjourn this, then that was an unfounded ground not to adjourn.
Well, let's assume again you're right about that. Judge should have adjourned it. What do we do?
Well, insofar as if your lordship is with me in relation to him not taking into account any harm to the respondent.
Well, you've got 2 points, haven't you?
Yeah.
You've got one is the judge should have deferred everything until the main proceedings are over.
Yeah.
The second point is that judge shouldn't have placed any weight on the potential flight risk.
Yeah.
Now, second point might have persuaded the judge to adjourn for 2-3 weeks, but not necessarily till the main proceedings were finished.
Well,
If that were the position, what do we do?
well, your lordship makes a good point to finish the morning session. I don't think there is anything your lordship could do. Perhaps it's just an observation.
All right. All right, well, let's stop there and start again at 2 o'clock.
Thank you very much.
Court rise at table.